dispensary license shall only be applicable for the use in the congressional district for which it is issued. A dispensary being operated outside of its designated area will result in the dispensary license being revoked. So we'll just have to add the specifics in.
I'll put a placeholder there.
Then, do we need to add anything? So transfer of licenses shall only be effective for the individuals and entities identified in the original application. A license may not sell, transfer, or otherwise dispose of his or her license to another individual without approval from the commission.
On these also don't have the ultimate changes you guys made on cultivation, so I can move those over.
So
as
what
well.
if a person had it in their will? Can they challenge this?
Challenge.
Like if I had a will or I had a estate planning that had a dispensary in it, properties, can that owner, that person can this challenge it based on that estate plan or will, or how does that work?
Well, they would have to be the person was deceased, and the other members of, let's say, the LLC wanted to allow that person to take over if they inherited that share. They would have to prove to you all that they were qualified to step into that role. These licenses aren't property that can be transferred. The business is property that can be transferred.
So they can own the dispensary, but they may have a dispensary without a license because the license isn't transferable.
They may own a business. Somebody would have to be qualified to hold the license before they could operate the dispensary.
So they would have to notify the commission that such and such has died, and we are requesting that based on this, that
Right.
within this.
I was thinking back to, I guess, attorneys can only attorneys can own law firms. But I think the provision would say that the law firm could keep operating. If my law firm was without me, and I would own 100% of it, my law firm could operate, I think, for 6 months while potentially the law firm went through probate to potentially be sold to another attorney or to transfer. So, one thing I guess we could think of is your point is really valid. I think would they have to shut down once that happens? Because what would happen is now your executor or your successor trustee is now going to step into the shoes of the deceased person and would own that quarter interest in the LLC. And so you potentially have a period of time where they wouldn't necessarily qualify because that person might not be the successor person might not be an Arkansas resident for 7 years, so you violate the 60% issue.
We deal with this with alcohol permits, and we have provisions that, you have, let's say, and this would be more covered in the operations of the cultivations and dispensaries, not necessarily for the application itself. But you have a certain number of days to notify that there's been a change in circumstances as you have here. And the business, there is no disruption in business. An application, a valid application has to be filed to replace that person if necessary. And it might not be necessary that it has, the only reason that would have to happen is we would have to be notified if they fell off or if there was a new owner, but there wouldn't be a disruption in operation necessarily unless the person who actually holds the permit, and if only entities hold the permits in this situation, it's probably not going to be that big of a deal.
So a dispensary has to be owned by an entity, can be owned by a person.
Well, the amendment, I think, contemplates that only Arkansas entities own these.
Right.
So that's not, it could be LLC with a sole member, I suppose.
Yeah, I was just, because it says no, may not transfer. I just want to make sure that if someone died or something that,
Well, they can't, right, they can't transfer the license because you don't have a property interest in the license. But if they notified you that the person had passed away, and they wanted to take over the license, they